Hello, everyone. My name is Sophia Pintar. I'm a legal intern here at Lyles Parker. Thank you so much for joining us in this new webinar series with the Home Care Association of Louisiana. Today's webinar is entitled Business Relationships with Referral Sources. Our presenters for today are Jennifer Papapanagiotou and Ashley Morgan. Jennifer Papanagiotou's practice focuses on compliance, regulatory, and transactional matters for a wide array of healthcare providers, including home health and hospice agencies. She has extensive experience in analyzing proposed and existing business arrangements for compliance with federal and state fraud and abuse laws, and drafting a wide variety of legal agreements. Ms. Papapanagiotou is knowledgeable in all aspects of state licensing for home health and hospice providers, and Medicare and Medicaid enrollment, including initial enrollment, changes of ownership, and appeals of revocation actions. Finally, she assists clients with compliance plans, forming new businesses, and addressing Medicare and Medicaid program coverage and reimbursement issues. Ashley Morgan is a partner at Lyles Parker's DC office. Ashley focuses her practice on regulatory healthcare compliance matters, fraud and abuse, and reimbursement issues. Ms. Morgan represents healthcare providers across the country in connection with a wide variety of health law issues, including coverage disputes, documentation concerns, compliance, medical board complaints, and exclusion termination issues. She has worked with an assortment of providers, including home health companies and hospice agencies. Ms. Morgan is also a certified professional coder, a certified medical reimbursement specialist, and a certified medical compliance officer. Without further ado, I present your speakers, Jennifer Papapanagiotou and Ashley Morgan.
Hi, everybody. This is Jennifer. Thanks for joining us, probably on your lunch hour today. We are going to, if you go to the next slide, please. Thanks, Sophia. First, a disclaimer, this outlines just general information. We're not giving you legal advice, and we always highly recommend you consult with your own legal attorney and get their advice if you have specific questions. Let's go to the next slide. So we are going to spend some time talking about business relationships between home health and hospice agencies and referral sources, and what are the laws that apply to that? What kind of guidance have we received from primarily federal authorities on enforcement of the federal statutes that we primarily concern ourselves with? And then we're going to go through some tips and tricks and best practices for crafting compliant arrangements. Let's go to the next slide. So when we think about business relationships and the sources of issues with those relationships, we kind of categorize them by where does the referral come from, or where does the financial relationship exist. So we look at relationships between agencies and physicians, between agencies and marketers, and then between agencies and facilities. Those are kind of the three biggest categories. And when we think about physician relationships, generally those are medical directorship type relationships. And examples of problematic areas are what we kind of generally call sham medical directorships, where physicians are paid for no services or they're overpaid for services. But we also see examples where agencies have multiple medical directors with compensation based on volume or value of referrals, or multiple medical directors who maybe look like they're paid on a compliant basis, but you really question the business necessity of having more than one, or more than two, depending on the size of the agency and what its scope is. The next big category of relationships we look at are marketers. Agencies often employ their own marketing staff. They do sometimes contract with outside marketing staff, and those have different legal requirements. So we really do look in the marketing side. We're looking at how are you paying the marketer, and what is their status, and if you've categorized them as an employer, are they really an employee? But we also look at the practices of the marketers themselves, and how much oversight are you providing for their activities, and are they being given opportunities to behave badly, essentially, on the job? Let's go to the next slide. And then the third category of relationships that we examine and that the federal authorities have spent a lot of time looking at over the years are relationships between agencies and facilities. And some examples of problematic areas are, kind of quid pro quo relationships between agencies and, let's say, nursing homes, where, you know, if you send me patients, I'll send you patients. Agencies overpaying for rent of space in a facility. That could be a nursing home, it could be assisted living facility, any kind of facility where you might have a source of patients. Free or below market value services provided by a hospice to a nursing home. This is generally hospice staff doing tasks that should be done by nursing home staff. Referring a home health or hospice patient to a nursing home in exchange for them referring back to you. Those have existed in cases that have been litigated in the past. And then an example that we've actually seen in some cases, and I see this more often than I thought I would in my practice, but an agency being given access to a facility's records to mine those records for referrals without specific patient permission. That's actually a violation of multiple statutes, not the least of which is HIPAA. So let's go to the next slide. I wanted to share with you just some example cases of how these problematic areas sort of play out in real life. And then as we go through the presentation, we're going to talk about the law that applies to these, and then we're going to talk about sort of what OIG has told us about their areas of concern and what their suggestions have been on how to address them. And then we're going to look at how to put this kind of into practice. So one of the most famous cases involving home health agencies and physicians is the Jacques Roy case, which was litigated here in the Northern District of Texas. I remember when this started, and it initially started as a big press release about Dr. Roy's indictment, but it also started with a slew of phone calls from home health agencies in Texas to their lawyers saying we've been suspended or we've been revoked, and they're saying there's something wrong with our relationship with Dr. Roy or one of his affiliates. So the Roy case affected, obviously, it involved Dr. Roy, but it also affected the, and I'm not lying when I say 500 different home health agencies he'd done business with. And some of them had done a lot of business with him, and others had just taken a referral from time to time from him, but got swept up in sort of the larger case that was going on. So Dr. Roy was a physician in the Dallas, Texas area. He had 11,000 plus patients, technically. That's their data count from the investigators that looked at this case, and was affiliated with about 500 different home health agencies. And when they say affiliated, they really mean he had been referring patients to them. The home health agencies would send their patients who needed a physician to order home health services to Dr. Roy, and he would then in return refer them back to the home health agency in exchange for some kind of money. He had these referral agreements with multiple agencies, and I wouldn't say of the 500 that are identified here, he had some kind of financial relationship with all of them, but he did have significant relationships with a number of them. They also involved home health agency personnel driving around Dallas, going to homeless shelters, or simply meeting people on the street and offering them money or items in exchange for their Medicare credentials. One patient recruiter, as a marketing person, was paying, $50 to each patient and offering to buy them food. Other home health agencies were going door to door in like senior living facilities or apartment complexes, looking for Medicare beneficiaries that might be willing to give up their Medicare credentials for some kind of money. Some home health agencies had as many as 80% of their patients on service referred by Dr. Roy, which was very unusual. And his office handled more home health visits than any other physician office in the country by a multiple of 10. He had more referrals to home health than any other physician in the country, and I would say probably 10 times more than most. With his volume, he had employees who were fraudulently signing his name to plans of care and certifications. He wasn't even necessarily looking at them. The government ultimately uncovered this fraud using data analytics, and they were running the numbers and seeing that he was falling way off the bell chart compared to his peer group, and ultimately initiated their investigation based on those data analytics. The Office of Inspector General, this is the Federal Health and Human Services Office of Inspector General, said that most physicians refer fewer than 100 patients for home health in a given year. He was referring tens of thousands, essentially. When Dr. Roy's first practice was suspended, and so they took action against him, he had a home visiting practice, and they suspended the practice, and he actually went on his own and created a second practice and just continued to do what he had been doing, and there was money flowing back and forth between the entities, and ultimately that got him charged not just with healthcare fraud, but also with obstruction of justice, because he actually went around a legal action implemented by the Medicare program to stop the fraud by creating another business and essentially trying to hide behind another entity. Ultimately, when this case finally went to trial, he was found guilty and sentenced to 35 years. And his co-conspirators were sentenced to somewhere between 3 to 17.5 years. And this did include some home health agency owners and administrators. Ultimately, he was ordered to repay $268 million in restitution. So this was a huge, huge bellwether case in home health fraud. This, again, was in the Northern District of Texas. We'll go to the next slide. I wanted to share an example of a hospice fraud case. This was based out of Missouri, and although it's a number of years ago, it was a good example of the different kinds of potentially inappropriate relationships we see sometimes in the hospice area. Good Shepherd was based in Oklahoma City, but provided services in a number of states and had 15 different offices. This was a whistleblower case, which is it's filed under the False Claims Act, and essentially a private party can file a lawsuit alleging that a provider is violating the Federal False Claims Act, and they can file that on behalf of the government. And I think everybody's heard the term whistleblower. In this case, the whistleblower was the executive director for one of the offices for about 6 months. And in that 6-month period was able to gather enough information to go out, hire a plaintiff's attorney, and file a lawsuit alleging a very significant fraud was being committed by Good Shepherd. The hospice was hiring medical directors based on their ability to refer patients, and they were focusing on medical directors specifically with ties to nursing homes. The hospice would have 4 or 5 medical directors who each worked a couple hours a month and were getting like $3,000 in salary a month. If you look at the face of the hospice medical director agreement, it might not be clear that that $3,000 was for just a couple hours a month of work. And I think most people would agree $1,500 an hour to a physician to serve as a medical director is most likely very excessive. And you wouldn't necessarily pick up, if you looked on an isolated basis, that these hospices had 4 or 5 different medical directors who were each getting this kind of salary for this little work. So you have to look at the whole picture together to really appreciate kind of the scope of what was going on. The hospice actually required the medical directors to refer at least 1 patient a month. That's a huge no-no in a hospice medical director relationship. You should never be requiring them to refer patients. In fact, one medical director was terminated for failing to bring in referrals, and he expressed concern about the quality of care as a reason for not referring patients, and they terminated him anyway. These are all like huge red flags. The hospice would keep at least 1 patient in a nursing home as a hospice patient just to ensure they had access to the nursing home to continue to market hospice services. They want to keep their foot in the door. So these are all sort of signs and red flags that made this case ripe for this whistleblower to file. Let's go to the next slide. Some other interesting facts in the Accordingly case: hospice nurses were performing the work of nursing home nurses when in a facility treating hospice patients. This is a quote: "If you give me 5 patients, I'll put a nurse's aide in your building all day long that you can use however you want." That's very, very inappropriate in a hospice nursing home relationship. The hospice was also paid for residents' room and board, even if it didn't receive Medicare payment due to faulty paperwork. There's sort of just, these can be examples of conduct that the government took exception with. And then there were hospice consultants, which really were marketers that were giving nursing home staff gift baskets and free lunches if they achieved a quota of referring at least 5 admissions a month. Again, you can't give freebies to referral sources. That's a huge no-no. Good Shepherd ultimately settled for $4 million, which honestly, in the big scheme of things, doesn't sound like that much money today. and were required to submit to a 5-year corporate integrity agreement with the Office of Inspector General. Let's go to the next slide. The last case I want to go through is the U.S. v. Dubois and Whitaker. Dubois owned Care Committers Health Services, and they were paying group home owners for access to and for referring Medicare beneficiaries. They were giving those group homeowners $500 for an initial certification and $250 for a recert. Payments were made both in cash and by check. Dubois paid marketers and recruiters, including Whitaker, who was one of the employee marketers, to find beneficiaries, and then beneficiaries were paid to sign blank home health forms. Dubois was criminally prosecuted and found guilty after a 4-day jury trial and was ultimately sentenced to 9 years in prison and to pay $3.5 million in restitution. So this is a good marketing case, sort of illustrating how the relationship with a marketer in and of itself can be problematic, but also can just the behavior of a marketer be problematic. So marketers are considered sources of referrals, whether they work for you as an employee or they work for you as an independent contractor. So it's something to keep in mind. We'll talk more about that. So let's go to the next slide. We're going to cover some of the key laws that govern this area and how it really kind of sets the stage for how we craft business relationships with referral sources. Let's go to the next slide. So healthcare spending has obviously been under a lot of scrutiny from an enforcement perspective at both the federal and the state level. And the laws that govern these business relationships are extraordinarily complex, and they are also ever evolving. It's not necessarily that the words of the law change constantly, but the interpretation of the law, whether that's from case decisions or cases that are ongoing, or it's just interpretive guidance that we get through the Office of Inspector General or through state authorities, sometimes from Department of Justice, depending on the kind of law it is, that is constantly sort of resetting our understanding of how the government interprets these laws and what they think is right and what they think is wrong. Keeping in mind, there's really two sides to this. There's the things that we as attorneys think about. What does the law say? What does it prohibit? How do you interpret that? If I had to litigate a case, how would I defend it? That's one thought process, and it's kind of in a vacuum. That's sort of a good academic exercise. We also have to think about the practical reality of crafting a business relationship that's going to keep you from ever being investigated, because what we don't want is the expense and the wasted time, effort, and money involved in an investigation. It is so burdensome that, a good attorney who understands this area of the law can help you craft arrangements that never get you into a position where you're going to have to be defending it. That's really our goal. So let's go to the next slide. Unfortunately, criminal prosecutions for healthcare fraud related to home health and hospice have been very active, continue to be very active, and integrity auditors are still also extremely active. As COVID wound down, I would say by mid-2022, we were seeing a huge upswing in the amount of auditing going on by UPICs and also by MACs through the TPE process. But we've seen a huge volume of audit activity. It's definitely back to what we would call normal pre-COVID levels. What we are also seeing is they're using the authority to suspend payments by the Medicare program liberally. We're often seeing suspensions go hand in hand with large, statistically significant audits going on. And revocations are also on the upswing. So if they feel like they have grounds to revoke, they're using that authority pretty extensively. So let's go to the next slide. There are a host of laws that govern healthcare fraud, waste, and abuse, and I've just listed a handful of them here. On the criminal side, we have the Anti-Kickback Statute and the Criminal Healthcare Fraud Statute. The Anti-Kickback Statute specifically governs federal payer programs, so Medicare and Medicaid are primarily the two biggest ones, but the Criminal Healthcare Fraud Statute, which we fondly refer to as 1347, is an all-payer statute, and you can be accused of criminal healthcare fraud unrelated to a federal healthcare program under this statute. The civil laws that we typically pay attention to are the Physician Self-Referral Statute, which we all commonly referred to as the Stark Law. That's a civil law, and it's what we call a strict liability law. You either comply with the statute or you don't. And if you don't comply, then bad things can happen. We'll talk about that in a minute. We concern ourselves with the False Claims Act. The False Claims Act is where the whistleblower cases come from. It's also where we see a huge, most civil investigations from the Department of Justice happen under the False Claims Act. Because the False Claims Act can pull in violations under other statutes. If you violate the Anti-Kickback Statute, for example, they can then attack the claims that were paid as a result of that kickback relationship under the False Claims Act and claw back the money. So the False Claims Act kind of ties these other things together. And then obviously HIPAA. We think of HIPAA as governing privacy of health information, but it also has a number of enforcement authorities that fall under the HIPAA statute that affect and can sort of enhance fines, penalties, and governs things like exclusion. So let's go to the next slide. Okay, so we're going to talk about primarily the Federal Anti-Kickback Statute, which is a criminal law, and the Stark Law, because those sort of have the most meat on them for how do we compliantly craft business relationships. So the Federal Anti-Kickback Statute prohibits the knowing or willful solicitation, receipt, offer, or pay of any remuneration, and this parenthetical is important, including a kickback, bribe, or rebate. Remuneration can be anything. It can be money, it can be opportunities, it can be things, tangible things, but remuneration really is anything of value in order to induce or reward business. This is payable under a federal healthcare program. Transactions among parties who refer to each other are subject to the Anti-Kickback Statute. So this is, when I say transaction or business arrangement, medical directorships, hiring independent contractors to do marketing, relationships between agencies and facilities, those are all that fall into that transaction category. And generally speaking, they've all been interpreted to offer the opportunity for a referral, even if that quote unquote referral is coming from somebody who's not necessarily a physician. I don't want the listeners to think that because a physician's not involved in a business relationship that it can't not be characterized as a referral. That is absolutely not the case. OIG has dispelled that notion in its guidance on these statutes. So they consider a nursing home or a marketer as being able to influence referrals, and that's enough to fall into this statute. If you're found guilty under the Anti-Kickback Statute, it can result in incarceration and fines. They've actually increased the penalties in 2018 from $25,000 to $100,000 per violation, and the maximum term of imprisonment from 5 years to 10 years for each violation of the statute. You can also be excluded from participation in federal healthcare programs. And again, as I said, remuneration can be an exchange of anything of value between a source of referrals and someone who might receive those referrals. Let's go to the next slide. Back in 2010, they modified the Anti-Kickback Statute when they passed the Affordable Care Act. And again, when we look at the Anti-Kickback Statute, it's an intent-based statute. They have to prove you knowingly and willfully engaged in the conduct. Well, they actually watered the actual meaning of what knowledge is when they passed the Affordable Care Act, and they said that you didn't have to have actual knowledge of the Anti-Kickback Statute or specific intent to commit a violation of the Anti-Kickback Statute. You just had to know what you were doing was illegal, essentially. It's a watered down version of what we consider to be actual knowledge and the way it had been interpreted by some courts prior to the Affordable Care Act. The touchstone really for healthcare lawyers, and when we think about business relationships, is what we call the one purpose rule. And this comes out of some case law from many, many, many years ago. It's a case called U.S. v. Grieber, where the Third Circuit decided that the Anti-Kickback Statute was violated if even one purpose of a payment to a physician was to induce that physician to refer a patient, even if the payments were also intended to compensate the physician for professional services. That's a really, really restrictive standard because you could have an entirely appropriate business relationship where you were paying that physician what appeared to be an appropriate amount of money to do something for you, But if even one purpose of that payment was to encourage referrals, then they could argue was a violation of the statute. Well, I mean, we had to do something about that to sort of protect legitimate business relationships. If we go to the next slide, we'll talk about what are called safe harbors. So when they started, let's go to the next slide. When they, in the early mid-90s, when the Anti-Kickback Statute was still fairly new, the Office of Inspector General was tasked under the statute with drafting what are called safe harbors. And these are actual regulations that define conduct that is low risk to the program. And essentially, if you meet all the terms of a safe harbor, then your arrangement is immunized from prosecution. And this was intended to protect relationships that were common in the industry and allow people to conduct business that needed to be conducted without worrying that they violate the law. Safe harbors under this criminal statute are voluntary. They are not mandatory. If you don't meet all the terms of a safe harbor, that doesn't mean you violate the law, but it does mean that the enforcement authorities are going to kind of look at all the facts and circumstances, and they're going to test this concept of whether one purpose of the relationship was to induce referrals. And they're going to look at that knowledge element, that knowing and willful violation. Did the parties have an illegal intent in entering into that relationship? There are currently 25 safe harbors. And they kind of grow and change over time. The terms of the safe harbors and how they're interpreted changes over time. We had a big revision to the safe harbors back in the sort of 2019, 2020, right as COVID was beginning, to bring them sort of in line with current practice, which was very, very helpful. We'll talk about some of the most important safe harbors on the next couple of slides. That is the one for personal services and management contracts, because that generally governs agency relationships with medical directors. We'll talk about the bona fide employee exception, which is often relied on with employed marketers. And then we'll talk a little bit about the space lease safe harbor that covers relationships between agencies and facilities where they may lease space for an office. Again, we get new safe harbors periodically, but for the most part, the three I mentioned are the most common ones that we rely on. So let's go to the next slide. We're going to look at the personal services and management contract safe harbor. It has a number of requirements. You may have heard of this before, but it requires a written signed agreement between the parties. That agreement has to cover and specify all of the services the agent's going to provide. It has to be for a minimum of 1 year. The compensation methodology needs to be set in advance and consistent with fair market value and not take into account the volume or value of referrals otherwise generated between the parties. The arrangement can't involve the counseling or promotion of a business arrangement or activity that violates any state or federal law, and the aggregate services contracted for must not exceed those which are reasonably necessary to accomplish the commercially reasonable business purpose of the service. So the structure of this sounds like something that should be fairly simple to implement, and there are so many ways it can go off the rails. I will highlight that the fourth requirement here is actually a revision to what the safe harbor originally looked at. It used to be that you had to set out the aggregate compensation over the term of the agreement in advance, and it could not vary. And it effectively kept hourly rate agreements, which were extremely common for medical directors, from falling and fitting within the safe harbor. They modified this back in like 2019-ish timeframe to say, no, we don't require you to set out the aggregate compensation. We just want you to set out the methodology for how you're going to determine the compensation in advance. And as long as that doesn't vary with the volume or value of referrals, we'll be okay with it. This effectively brought all of those hourly rate medical director agreements that met all the other requirements of this exception under the safe harbor, which was something that was desperately needed. Let's go to the next slide. The second safe harbor that we think about a lot is the space lease safe harbor. This would cover, let's say you're a home health agency and you lease space at an assisted living facility or at a nursing facility or senior living type arrangement. It requires a written agreement signed by the parties that covers and specifies all of the premises leased between the parties. And if it's a part-time lease, it has to specify the exact schedule of use. It has to be for a minimum 1 year term, And this one has not changed. The aggregate rent has to be set in advance and consistent with fair market value and not take into account the volume or value of referrals between the parties. The services performed must not involve counseling or promotion of an illegal business arrangement, and it cannot exceed what is reasonably necessary to accomplish commercially reasonable business purpose of the rental. Now, the biggest way I see space leases for home health or hospice people who have, let's say you rent an office in a facility because you have a lot of patients there, the way these go off the rails are twofold. One, you overpay for the rent, too much money, it's not commercially reasonable rent, or you rent a space but it's not actually being used. And all of those are considered sort of disguised ways to give a kickback to that facility so that in exchange they will recommend your services. Let's go to the next slide. The last safe harbor we'll talk about is the employment safe harbor. This requires that remuneration it carves out remuneration paid by an employer to an employee who has a bona fide employment relationship with the employer. The problem with this is that they very much look closely at whether the person you're trying to protect with this safe harbor was really a bona fide employee, and they apply the IRS test, which I've given the citation for that. This comes up a ton in marketer kickback cases where the marketers paid a commission or on some kind of success basis. The key factors in prosecuted cases that we've seen generally look at whether that person really was an employee or not. They look at the form of payment, whether it was hourly or salary, or was it a pure commission, or was it heavily weighted to commission. They look at whether the alleged employee actually had an office at the employer's location, whether that employee received training that other employees received, whether that employee set their own hours or worked full-time or were subject to the sort of authority and supervision of the employer, and whether the employer paid all the expenses of the alleged employee. They're really looking at whether that person was truly treated like all the other employees of the business, or were they really was calling them an employee just another way of trying to protect that relationship. Let's go to the next slide. So we want to touch on the civil statute that we deal with most commonly, and I put this one second because its application is a little more narrow than the anti-kickback statute. The Stark Law, as I said, is a civil statute, and it prohibits a physician, and it really just applies to physicians, from making referrals for certain what are called designated health services to an entity in which the physician or a member of his or her family has a financial relationship, unless an exception applies. The biggest example of this in the home health hospice space are medical director agreements, which are subject to this law. Importantly, penalties for violating this statute, $15,000 for each claim submitted in violation of the law, up to $100,000 for each scheme that violates the law. Also, denial of payment for the designated health services that were referred in violation of the law, and refund of the amounts that were paid as a result of those tainted referrals, plus treble damages on top of that. So take whatever the amount of money that the claims that they allege were tainted and triple it. And they can also exclude the parties from participation in federal health care programs. So the penalties are very, very severe. Let's go to the next slide. The key terms in this statute to focus on are, one, what is the financial relationship? Let's go back one slide, please. What is the financial relationship that's subject to the law? That can be a compensation relationship, like a medical director agreement, and it can also be an ownership or investment interest. The most common, as I said, is these medical director arrangements. The other really key term to focus on here is what we call DHS, or designated health services. If there's no financial relationship, or there is one, let's say there is a financial relationship, but if it doesn't involve designated health services, then the Stark Law doesn't even apply. Home health services are designated health services. Hospice services are not. And so we don't worry about the Stark Law when we're talking about hospice. We do worry about the anti-kickback statute, though. So you're still involved, but this is just one law you cannot have to worry about if you're in hospice. Stark applies to a physician financial relationship if that physician will ever refer a Medicare patient to the home health agency. And as I said, it's a strict liability statute. You have to comply with an exception or you're in violation of the law. Let's go to the next slide. Another really important thing I want to point out is in the home health payment regulations, there's a regulation that expressly prohibits a physician or non-physician practitioner from certifying, recertifying, or establishing a plan of care if he or she has a financial relationship with a home health agency, unless that relationship complies with a Stark exception. So they've, kind of gone full circle here and said we've established the Stark law and all of the penalties that it can assess, and then we're also going to put into the payment regulations that you can't get paid for an illegal referral, and that's in 424.22D. The Stark exceptions are very similar to the Anti-Kickback Statute safe harbors. We have exceptions for personal services arrangements, office-based leases, and bona fide employment relationships, just like we do under Anti-Kickback Statute, and the terms are very, very similar. I'm not going to go back through the Stark law exceptions because they are so similar to the Anti-Kickback Statute ones. I'll just remind you that if you're a home health agency and you have medical directors, you got to make sure you comply with this one. Okay, I'm going to turn things over to Ashley, who's going to talk a little bit more about the interpretive guidance and our best practices for how to craft compliant arrangements.
Thank you, Jennifer. So Jennifer has covered the major statutes and implementing regulations that we worry about every day, but along with those comes a lot of interpretive guidance, and we can go ahead and go to the next slide. So this is some of that interpretive guidance. You'll see a lot of it comes from the HHS OIG, the Office of the Inspector General. Just some examples, and you can see the dates that we have here. I mean, we've got guidance back to 1995 that have issued special fraud alerts, or is also compliance program guidance both for home health agencies and for hospice. And these documents help us identify things that could be problematic and how agencies can be in compliance. They let us know what the government's worried about or actively investigating, and how we can properly interpret the law. Even though the compliance program guidance for home health agencies and hospices, has been out for over 20 years, it's still a really great tool for helping agencies develop and implement a compliance program. Fraud alerts, and we're going to talk about some of those as well. Those generally identify current issues in specific industries, and those come out sporadically from the OIG as well. So let's go ahead and go to the next slide. Okay, and then the next slide again. So we're going to start talking about some home health agency guidance that's been issued. So first, we're going to talk about the OIG special fraud alert that was issued for home health agencies back in August of 1995. Again, it's from 1995. It is still relevant. The OIG identified a number of problematic arrangements that are likely to violate the Anti-Kickback Statute. And specifically, they are addressing home health agencies offering kickbacks to physicians, beneficiaries, hospitals, and rest homes in return for referrals of beneficiaries. Some examples that are provided in that guidance include providing hospitals with discharge planners, home health care coordinators, or home care liaisons in order to induce referrals. Another problematic situation would be providing free services such as 24-hour nursing coverage to retirement homes or to adult congregate living facilities in return for home health referrals. Another situation that was identified was subcontracting with retirement homes or adult congregate living facilities for the provision of home health services to induce the facility to make referrals. And then also pressuring physicians to order unnecessary personal care services by telling them that patients were requesting the services and that they would refer those patients to other physicians unless they ordered them. So again, these are things that the OIG has specifically identified can be problematic in connection with violation of the Anti-Kickback Statute. So, if your agency, is engaging in any of these things, something to flag during your compliance review and something to avoid in participating in to avoid, liability under the Anti-Kickback Statute. Next slide. So now we're going to talk about the compliance program guidance for home health agencies. Again, this was issued in 1998, but it is still helpful today. One of the most helpful parts of the compliance program guidance For any of the compliance program guidances, there's also ones, for small physician offices. There's a variety of specific compliance program guidances that have been issued. But one of the most helpful portions is the risk areas that the OIG identifies, because those are things that, the OIG has said these are areas that are problematic. You should watch out for these, home health agency or whichever provider type you are. And so the risk areas that were identified in this program guidance for home health agencies included incentives to actual or potential referral sources. So physicians, hospitals, patients. An example would be the home health agency paying a fee to a physician for each plan of care certified. That can be a problem. Providing nursing or administrative services for free or below fair market value to physicians, hospitals, and other potential referral sources, or providing salaries to a referring physician for services either not rendered or in excess of the fair market value for services rendered. We see that a lot with medical director agreements that potentially becoming a problem. So again, paying specific fees for, plans of care, providing free services, or paying, a salary for, services provided by somebody that, doesn't really justify the work that they're performing. Another potential risk area is services provided to patients who reside in assisted living facilities. So this can include a space rental that does not meet the safe harbor. If you're renting space from an assisted living facility and that space rental, doesn't justify what the fair market value would be for that actual space, that can be a problem. Or in addition to the provision of services that are otherwise covered under the resident's contract or required under state licensure, the assisted living facility should be providing that, not the home health service. Obviously, if the government sees that the home health agency is providing those services that the assisted living facility should be providing, and there's no payment being made for those, or not a fair market value being paid, and then referrals are going through, that can be very problematic. And additionally, compensation programs that offer incentives for the number of visits performed and the revenue generated. So again, if you're going to have arrangements with physicians, or you're going to rent space from a facility that may end up referring patients, it's important to make sure that any payment, is in fact fair market value and is otherwise meeting safe harbor criteria. Next slide. And so here is some of the guidance on specific home health policies. This is from that same compliance program guidance document, and some specific discussion on policies for home health agencies. That would include that all of the agency's contracts and arrangements with actual or potential referral sources are reviewed carefully for compliance with all applicable statutes and regulations. That is very important. Again, this is from 1998, but still very good advice, a very good policy that you're actually reviewing all of your contracts I suggest working with a healthcare attorney that's experienced in the area to make sure that they do in fact comply with all the applicable statutes and regulations. As Jennifer just indicated, one of the rules has recently changed on the payment structure. So these rules change, and you need to make sure that your contracts maintain compliance with law. Another guidance point on policies would be that the agency does not submit or cause to be submitted to the federal healthcare program claims for patients who are referred to the agency pursuant to contracts or financial arrangements that were designed to induce referrals in violation of the Anti-Kickback Statute. So, that's a really an internal review point to make sure that you're not receiving referrals from somebody that you have a financial arrangement with, and that financial arrangement really is a guise to induce referrals. That's something that you need to look at, and you should have a general policy of internally monitoring that. And another point would be that you're not offering gifts, free services, or other incentives to patients, relatives of patients, physicians, nursing facilities, hospitals, contractors, or other potential referral sources for the purpose of inducing referrals. I know that kind of goes against, human nature. You want to thank people for the nice things that they do for you. You want to send a gift basket at the holidays, but you have to be very careful about that because that can, in fact, be a violation. There's no de minimis amount for the anti-kickback statute. Next slide. And so this is a more recent OIG alert and a fraud alert, and it was in regard to improper arrangements and conduct involving home health agencies. It came out in June of 2016. There are several more OIG alerts also relevant to home health agencies, but we wanted to point out this one specifically. And we've got the hyperlink here on the screen for you if you want to go take a look at it yourself. But it specifically discusses practices that the OIG has found in investigations and studies of home health agencies, physicians, and home visiting physician companies. And it specifically is talking about criminal convictions and settlements, which included making and accepting payments for patient referrals, falsely certifying patients as homebound, and payments for referring or soliciting Medicare and Medicaid patients that sometimes involve payments to physicians disguised as payments for serving as medical directors. So again, that medical director relationship becoming problematic. That's something that gets looked at closely. So you do need to ensure, if you do have medical directors associated with your agency, that those contracts do meet the the rules, and you need to evaluate whether you're receiving referrals from that provider. All right, next slide, please. Okay, now we're going to look at some hospice guidance. So the first interpretive guidance we're going to look at is the OIG fraud alert that was issued in regard to nursing home arrangements with hospices. This dates back to 1998 again. And this one is focused on hospices overpaying nursing facilities for room and board. The OIG specifically said it had observed instances of potential kickbacks between hospices and nursing homes to influence the referral of patients. Specifically, payments by a hospice to a nursing home for room and board provided to a Medicaid hospice patient should not exceed what the nursing home would otherwise have received if the patient had not been enrolled in hospice. Any additional payment must represent the fair market value of additional services actually provided to that patient and are not included in the Medicaid daily rate. It also discussed specific practices that are suspected to be kickbacks, and we have a list of those on the screen for you. Those can include a hospice offering free goods or below fair market value goods to induce nursing homes to refer patients. Again, paying their room and board in excess of what the nursing home would have received directly from Medicaid had the patient not been enrolled in hospice. The hospice paying amounts to the nursing home for additional services that Medicaid considers to be included in its room and board. Reciprocal referral relationships, the hospice to the nursing home in exchange for nursing home to hospice. A hospice providing free or below fair market value care to nursing home patients for whom the nursing home is receiving Medicare payment under the skilled nursing facility benefit, with the expectation that after the patient exhausts the skilled nursing facility benefit, the patient will receive hospice services from that hospice, and a hospice providing staff at its expense to the nursing home to perform duties that would otherwise be performed by the nursing home. The takeaway really from this is to stay in your lane and don't play games with the room and board arrangements. And again, ensure that any payments made are for fair market value. Next slide. So now we're going to quickly look at the compliance program guidance for hospices, again, back to 1999, but it's still very relevant today. We're going to talk about the risk areas first. The risk areas that were identified for hospices that are still relevant include incentives to referral sources. So if you're giving incentives to your physicians, nursing homes, hospitals, etc., those could violate the Anti-Kickback Statute or other similar federal and state statutes or regulations, including improper arrangements with nursing homes. You'll notice that with hospice specifically, there's a lot of focus on nursing homes. But some examples would be paying the fee for each terminal illness certification or providing nursing, administrative, or other services to physicians, nursing homes, or hospitals, and other potential referral sources. really to influence those referrals. So, you shouldn't be, doing paperwork or whatever for your referral sources as a way to try to induce more referrals. Or again, excessive room and board payments to nursing homes. Another risk area that was identified was providing hospice services in the nursing home without a finalized written agreement. If you must have a written agreement with a nursing home under which the hospice takes full responsibility for the management of hospice care and the facility agrees to provide room and board. Another issue would be improper patient solicitation activities such as patient charting, a review of patient records in an assisted living facility without the patient's approval to mine the resident population for hospice services. Obviously, that's a problem to be looking through the charts to try to identify who could be a potential hospice patient. And sales commission based on the length of stay in hospice. This may cause recruitment of long stay patients whose stays may be ineligible for hospice benefits. And on the next slide, we're going to talk about some policies for hospices that the OIG identified. So this is just some advice on what your policy should address. So all of your hospice contracts and arrangements with actual or potential referral sources are carefully reviewed for compliance with all applicable regulations and statutes, that the hospice does not submit or cause to be submitted to the federal healthcare program's claims for patients who are referred to the hospice pursuant to contracts or financial arrangements that were designed to induce referrals. And again, the hospice does not offer or provide gifts, free services, or other incentives to patients, relatives of patients, physicians, nursing facilities, hospitals, or other potential referral sources. So these are very similar to the policies for home health, but again, all applicable and important to keep in mind when you are, looking at your compliance plan to ensure that you have policies that address these specific issues that the OIG has identified. Next slide. And just a few additional ones. The hospice is offering free or below fair market value goods to induce a nursing home to refer patients to hospice. If you're paying room and board, payments to nursing homes in excess amounts, or if you're paying above fair market value for additional non-core services and Medicaid does not consider to be included in room and board, these can all be problematic areas that, when you're doing your internal audits, you need to take a look at these because they could be considered potential kickbacks. So take a look when you're doing, your regular internal monitoring and auditing for these specific issues to ensure that you are in fact in compliance. Next slide. Okay, so, and this is a fraud alert that was specific to physician compensation arrangements that may result in significant liability. This one came out in 2015. This is talking about medical director payments and highlighted problems that resulted in civil or criminal liability. It specifically discusses a settlement with 12 individual physicians. And we've got the hyperlink again here for you if you want to check it out for yourself. But some of the things that are discussed in regard to the compensation relationships that were involved included payments that varied with the volume or value of referrals and did not reflect the fair market value for the services performed. Non-performance by physicians of services called for under the agreement, for example, a medical director agreement, and payment of salaries for physician office staff by the hospice. So just a couple things to flag and to be aware of as things that the OIG has identified as problematic. And now we're going to talk about some tips and best practices to keep in mind. So obviously educate yourself. Make sure you understand the Anti-Kickback Statute, the Stark Law, and relevant state laws. Retain counsel and not just, general business counsel. Make sure you have healthcare counsel that's knowledgeable about these types of issues. And always keep in mind, we always like to say that everything that you as a provider says in connection with an audit or an investigation is considered evidence. Everything your attorney says is an argument. So generally, it's best policy to have representation if you are in fact under audit or under an investigation. And If you don't have a compliance plan in place, absolutely, please put one in place. A good place to start are those compliance, the OIG compliance program guidances. Again, even though they're from the 1990s, they're still a great place to start to identify your risk areas and to get some sample policies to put in place, and get a compliance plan that you can work with that's tailored to you. Next slide. So some specific best practices and tips that are related specifically to physician relationships would be to ensure that every relationship with the physician is documented and reviewed by a healthcare attorney. Make sure that it documents valid business rationale for the services and that you're paying actual fair market value for the services. If you do have a medical director, they should only be compensated for clinical and administrative services. There should not be a link to referrals or admissions. This is really important and something that we see that does not occur often, or as often as it should, is that physicians should document time to support payment for the medical director services. They should document, the time they're spending doing their medical director services, the specific activities they were performing. Having that documentation is extremely helpful in if you are subsequently audited or investigated in regard to a referral relationship. Being able to prove the amount of time the physician spent doing the work and what they were doing is really critical, and showing that you were not in fact paying for referrals. They were paying for actual services by that physician. And on your end, you can request invoices that do in fact show that the services were provided and the hours worked are reasonable, and keep those on file to protect yourselves as the home health or as the hospice agency. You should also train your medical directors on eligibility criteria, Medicare definitions, and compliance with the law, and monitor your relationships with outside referring physicians, their offices, and marketers as a part of your compliance program. Next slide. And one additional thing to keep in mind is that you do want to screen your physician referral sources and your medical directors monthly for exclusions. Obviously, you should also be including, your staff as well and screening them. But include your physician referral sources and your medical directors too. So to ensure that, you don't have patients that are being referred by somebody who, is ineligible to participate with the federal and state healthcare programs. And the lists we have for you are on the screen: the CMS ordering and referring database, we've got the Louisiana state database, and the OIG LEIE. Really, you should also be screening all of the state databases available, but at a minimum, you need to make sure you're at least reviewing these. Next slide. So some best practices in regard to marketing staff. Ensure that your employees are truly employees. Consider the IRS definition that Jennifer discussed earlier. Again, consider behavioral control, financial control, the type of relationship. You need to evaluate compensation plans for marketing employees. Make sure it's not based on the number of admissions or length of stay. Even though there is, in fact, a bona fide employment safe harbor exception, note that many cases involving employees are still problematic, and keep that one purpose rule that Jennifer discussed in mind. And if you do have incentive payments, those should not be based on individual economic production. Compensation for marketing by independent contractors needs to meet the personal services safe harbor. So again, there's different safe harbors, whether your marketing employees are actual bona fide employees or whether they're 1099s under the personal services safe harbor. If they're 1099s under the personal services safe harbor, then you need to make sure that their compensation is at fair market value and not based on the volume or value of referrals. The fixed fee needs to be determined in advance, and that the contracted services should be valid services and not a cover for referrals. Next slide. A couple other tips in regard to marketing staff. Separate the marketing function from the intake and admission function. Intake and admissions personnel should not receive bonuses based on new patients that are admitted. Stay away from quotas for admissions. Don't fire people for failure to meet their goals. Beware of excessive focus on numbers and revenue. Routinely check your referral patterns. Unless you're in a rural or underserved area, you probably should not have more than about 20% of your referrals coming from any one physician. Make sure you train your marketers and admissions and recertification personnel on eligibility criteria, Medicare definitions, and compliance with the law. And monitor your marketing practices of independent contractors, as well as your employees and their relationships with your referral sources. Don't just send them out and never check on what they're doing. You do need to monitor, what they are doing to market your services. Next slide. And finally, for marketing staff, avoid offering free or discounted services to other healthcare providers or facilities in connection with home health or hospice patients. This is, again, especially important in hospice relationships with nursing facilities. And I know we're at our time, but we're almost done. One more slide, I think, or two more. For facility relationships, some tips and best practices would be to document the relationship between the home health agency or the hospice in any facility. Make sure it's compliantly structured, written. If you have a lease agreement, make sure you have a written, signed lease agreement between the agency and whatever facility the lease is with. For nursing home and hospice agreements, make sure those are written, signed. They address the hospice's responsibility for all care and the nursing home's responsibility to provide room and board. And next slide. Always a good tip, if you are in doubt, reach out to your healthcare attorney, get them to evaluate your contracts, get them to evaluate the relationship, and get that advice, because these are very complex situations. And it's much better to ask in advance than to proceed and, find out down the road that you're under investigation or that you've done something that's problematic. And now, you're dealing with it, retroactively. Do we have any questions?
As what I see, we do not have any questions at this moment. So I'm going to let Sophia close the webinar.
Thank you. And thank you so much to our presenters, Jennifer and Ashley, for that information. And thank you to our attendees for joining us today. We'll be sending out a copy of the PowerPoint slides tomorrow. And if you have any further questions, please reach out to them. Have a great Tuesday.